Hello, and welcome to Due Process. This is Trevor Wadden. This episode features the director of the UBC Innocence Project, Tamara Levy Q.C. I'm actually recording this introduction well after recording the interview with Tamara, who I spoke with in December of 2020. I'm grateful to Tamara, as she has been a source of information and support throughout my podcast journey. She was the first interview I conducted for this podcast, and she was patient, insightful, and gracious with her time. In fact, Tamara provided such great information that following this interview, I started to consider the idea that maybe I could release full-length interviews as standalone episodes while I worked on putting together our main show, Due Process. This interview will also serve as a bit of a preview of the topics we will be reviewing in our first season. Tamara and I discussed many of said topics, including wrongful convictions, the creation of the UBC Innocence Project, the recent success in exonerating Tomas Yebes, the hallmarks of wrongful convictions, the use of science in writing miscarriages of justice, the need to revisit historic cases and convictions, jailhouse informants, juries, and demeanor evidence. As you will hear, Tamara and I spent several minutes discussing the case and wrongful conviction of Tomas Yebes, who was convicted of killing his two adopted sons in 1982 by essentially killing them and starting a fire to cover up the murders. Just so everyone listening is on the same page, Yebes' conviction relied heavily on the use of a fire expert who determined the fire was intentionally started, and on circumstantial evidence, namely that the family was struggling to integrate the boys into the family. There was marital strife, and ultimately, the court found that Yebes had motive and exclusive opportunity to kill the boys. Thanks to Tamara and the UBC Innocence Project, new expert evidence was acquired which showed that the fires were tragically, but accidentally set by the boys, meaning no crime had actually occurred. And in November 2020, Yebes, after 37 years of maintaining his innocence, was finally acquitted of the charges by a court in British Columbia. I wanted to provide this summary to avoid any confusion and make it easier to follow along in the beginning. With that backdrop, let me properly introduce Tamara. Tamara Levy Q.C. has her law degree from Osgoode Hall Law School, and she has practiced law for many years, including experience as Crown Counsel. She is the co-founder and director of the University of British Columbia's Innocence Project, an organization that is connected to UBC's Allard School of Law, where they seek to exonerate the wrongfully convicted and right miscarriages of justice. Tamara is also a co-founder of the Criminal Defense Advocacy Society, a network of lawyers that seeks to reform Canada's criminal justice system and to mentor young and upcoming lawyers. Tamara is an educator, mentor, and advocate for criminal justice reform, and her contributions to BC's legal community was recognized in 2017 when she was awarded her Queen's Counsel designation in British Columbia. So, without further delay, please enjoy this interview with Tamara Levy. Hi.
Hi.
Can you hear me?
Hi.
Hi. Good. How are you?
Good.
Good. Thank you for doing this.
Pleasure.
I am mindful of your time today, so I figure we would just jump right into it if that works for you.
Yeah, absolutely. Yeah, there's lots to cover and talk about.
There's lots we could spend all day talking about all of this stuff, I'm sure. So I will have properly introduced you in our podcast, but if you could just state your name and tell me a bit about your background and what you do professionally.
My name is Tamara Levy. I'm the director of the UBC Innocence Project, which is a legal clinic at the Allard School of Law, where we review claims of wrongful conviction in British Columbia, sometimes other provinces.
And it started in 2007, correct?
Yes, we started planning this project in early 2006, and then we opened the doors for applications in September 2007.
And can I ask you, why did you get involved with this type of work?
I started to learn about innocence projects when I was teaching a course on evidence at the law school, and it was an upper year seminar on sort of difficult topics in criminal evidence, and those topics included jailhouse informant evidence and confessions and eyewitness identification. And as I was preparing to teach that seminar and reading more and more about those areas of evidence, I learned about Innocence Project. And in learning about Innocence Projects, I started to wonder why we didn't have one in British Columbia. And I approached another professor at the law school who I had previously worked with when I was articling, and he had been approached recently by a group of students who were also interested in this topic and had started talking to him about it. So we all got together and we included another colleague of ours who's now on the provincial court bench here in British Columbia. And we started to meet regularly and plan, look at all the different models of innocence projects that have occurred, around the world, but mostly in the United States, to see what type of model might work for UBC in British Columbia. And we put together a proposal that Professor Harris brought forward to the curriculum committee, and they passed it and accepted it as a clinic at the law school for which students could get credit. And we opened our doors. We signed up 10 students who applied and started working on, I think the first year we had 3 cases that we divided sort of among the 10 students and started looking at them. And in conjunction with the clinical work, reviewing the actual cases, we also have a seminar that accompanies the course that we really tried to focus towards practical areas that arise in wrongful convictions that law students are frequently not exposed to in law school, like expert evidence and lawyers coming in to talk about, reviewing transcripts and writing and drafting. And those were all areas that students generally don't get exposed to in law school. And in addition to the weekly meetings and hearing from those types of experts, we had students, they have to do a co-requisite, which is a course on preventing wrongful convictions. And that's the course that I was teaching before we started the program, looking at the various players in the justice system, what their ideal roles are, looking at the role of the police, the role of the Crown, the role of the judge, the role of the expert, the role of defense counsel, and then also looking at those areas of evidence that have been identified as problematic in cases of wrongful conviction.
Okay. No, that's great. I think from my own experience in law school, we talked about some of the wrongful convictions and reviewed the royal inquiries and different things, but we didn't really spend a tremendous amount of time looking at the common elements or the issues that you see creeping into these cases in most of them. So I think that's a great experience for UBC students to have.
Yeah, the students really seem to love it. We have a forensic entomologist come in every year. We have a forensic pathologist come in every year, a DNA expert. And even though in the early stages of a career in criminal law, you may not be coming across experts like this who generally present in homicide trials, but the exposure to them and knowing that these are areas of expertise that are available was not only interesting for the students, but good for them to have, on the radar if they're junioring a case or in the future, to know even to ask the question, were bugs collected at the crime scene, and how thoroughly and how carefully and who reviewed them. Most people don't even know what forensic entomology is and how it relates so carefully and often accurately to time of death. And forensic pathology, many people don't know that it, is very much an art, and pathologists can have different opinions about important areas of evidence. So those are, if you don't know those types of things, you don't know the right questions to ask when you're reviewing a file. And DNA as well, it's the gold standard. We think of it in criminal law as the gold standard of evidence, but we've learned over the years that there are even problems with DNA evidence, and you have to really look at how the evidence was collected, stored, tested. There's just so many questions to ask, and if you're not exposed to those areas before you begin practice, you don't know to ask the right questions.
Absolutely. And one thing I will want to talk to you about is the Yebes case, which is, I think, shows kind of the difficulty with reviewing expert evidence and having that expert opinion. One thing I've been thinking about is how the justice system very much is a human, as you've said, a human endeavor, and where everybody involved is humans, from Crown to defense to police to judges and juries. And there's just so many opportunity for biases and mistakes to happen. And I think the Yebes case in general really exemplifies that in terms of the jury was really given expert evidence that at the time they felt they could put a lot of weight in, did put a lot of weight in. And it's something I've been kind of struggling with, is how, what are we doing today that in 20, 30 years from now, we're going to look back and say, oh, we really dropped the ball, or we made mistakes relying on this type of evidence.
Absolutely. Coming back to your accurate recognition that the justice system is a human endeavor. Whenever I am giving a presentation, I usually open with the quote from former Chief Justice Bev McLaughlin on, she was giving a lecture to other judges, and she said the justice system is a human endeavor, and like any human endeavor, it will have its share of mistakes, and our job is to find them and correct them. It's just so important to remember that we rely on witnesses who are human, and we as humans can always be wrong in so many different ways. And and as science evolves, as it always will, we will always be learning, and we always have to be open to the possibility of error or differences of opinion. And, in those scientific areas where there are differences of opinion, you have to ask whether it's safe to base a criminal conviction, where two people equally qualified disagree in a particular area.
Right. So just to go back to your UBC Innocence Project, there's usually about 10 students involved.
We started off taking 10, and then the law school was looking to increase its clinical offering. So we now take 15. We had like 10 or 11 for a number of years, and now we take 15. I capped it at that. So we can't more than that. And we have students apply with a resume and a statement about why they're interested in this particular clinic. They apply at the end of around March of their first year to participate in second year, or at the end of their second year to participate in third year. But I found that mostly I have second year students, which is great, because when they get into their case and committed to their case, they often want to stay for third year as a volunteer or do some piece of their case as a directed research project. So the longer we have them, the better, and then, as you've maybe seen, we have some students who are now lawyers on the cases and have stuck with the cases for years and years. And that consistency is just so helpful for the client, and helpful for the case, just for institutional memory about things that have gone on. Right. In an ideal world, we would have a full-time commission that reviewed these types of cases, that had one lawyer on them for as long as it took for the review. But we're not in that world yet. Hopefully we will be soon. And in the meantime, we have students who change every year. And, I feel bad every year when that client gets a new letter. Hi, I'm the new student on your case, and I'll be working on it, and here's what we're doing. But it's all we have right now. And I think that person would prefer to have students under supervision of experienced lawyers, at least, be looking at the file, than it just be sitting in a box somewhere.
Absolutely. But I imagine there would be a lot of documents and things that they'd have to bring themselves up to speed with. I know from the case that we're focusing on to kind of lead us through some of these different issues in the first season, Peter Beckett's case has over 34,000 documents, and that's about 11 years of ongoing proceedings. And with going back to Yebes, that's 30 years or so of worth of documents and different things they have to get their head wrapped around. So
and I should correct you now. I know it's been in the news as Yebes, but it's Yebes.
Yebes. Oh, okay. Yeah. Thank you. Thank you for correcting.
Yeah, he's a Spanish gentleman.
Yebes.
Yebes. And even I had incorrectly pronounced it for a decade as Yebes, but it's Yebes.
Okay, that's good to know. Thank you. So in terms of how many applications you guys would receive in a given year, is there kind of an average?
Yeah, and it's not big. I mean, applications that we actually take in terms of doing any kind of further investigation, I would say maybe one or two a year. Yeah, I think maybe 1 year we had 3. Okay. We get far more applications than that in terms of inquiries and people wanting our assistance. But in terms of cases that meet our criteria, which are deliberately very narrow, 1 or 2 a year of cases that we sort of start to look at.
That would meet your criteria. Can you just remind me what the criteria is?
Yeah, absolutely. We take cases where the person has exhausted their appeals in British Columbia. They're usually BC cases where they've exhausted their appeals, or they have at least attempted to get legal aid to pursue an appeal, and maybe legal aid has been refused, so they couldn't pursue it. They're serious cases, and we've said that, where the person has been sentenced to 2 years or more, so a federal term. But we only at the moment and for several years now have had homicide cases. And I think that's just because the process takes so long that only people who are in prison for life are really going to be pursuing this kind of application.
And I thought we could maybe look at Yebes as a way to kind of explain to, or show people just the amount of work that would go into a case like this.
Yeah. I should also add, sorry, I forgot.
Yep.
And we only take cases where the applicant is claiming factual innocence,
right,
versus a legal defense. And that's an important consideration. If not to dismiss the importance of legal defenses in criminal cases, but where we have limited resources, we're only taking cases where the person says, I didn't commit this crime, or like in Yebes, where it looks like potentially no crime was committed and the deaths were accidental.
And I will be mentioning the case in the podcast, but I'll give a summary for everybody. But just for time purposes, in terms of receiving the application from Yebes, and I know there was kind of a personal connection. I'm just wondering if you could maybe take us through, okay, the case meets the criteria, UBC is going to get involved, and just kind of take us through the process and just to illustrate how much work goes into something like this.
Yes, well, the Yebes case came to us through a student that applied to be a caseworker in 2010. And in his interview, when I asked him, why is this project meaningful to you? He told me about this case of his uncle, where his family had always believed in his uncle's innocence. And we said, well, we should take a look at that case. And so we started to look at it in September of 2010. And so that process, of course, entails meeting with the applicant, reading all of the transcripts, reading all of the decisions, trying to get your mind around what some of the issues could be. And is this a case of, some cases are very clear that they could not possibly be accidental deaths, but in other cases like Yebes, it was a question for sure on the table, or is this a case where the deaths were not accidental and somebody else committed this crime? And looking at that, we try to look at every potential issue. So it involved research first into, the fire science and the pathology and the toxicology, looking at other wrongful convictions where maybe that type of evidence had been questioned, and then consulting experts, finding the right expert, finding an expert, finding funding for that expert, making sure we can afford to pay for an expert, consulting with that expert, explaining the case to him or what the questions we have, then getting a report from the expert, and like this takes years and years and years. And I should say that early on as well, once we've sort of got beyond, okay, this case is eligible, meets our criteria, I'll look for supervising counsel on a case who will help take the case and focus specifically on that case, because as the director, we have 20 cases approximately going at any given time, all, as you say, with the volume of documents, that is really enormous.
Right.
And so the lawyers are, the supervising lawyers assigned to the case are the ones who are expected to really become familiar with that material and help guide the student in their research. And then I act as, I obviously know a lot about the case, but they are the ones who read the transcripts and sit down and go through the expert reports in detail and follow up with the experts and ultimately draft the legal submissions, whether it be to the minister or the court. And I have some input and some editing sometimes, but those supervising lawyers do a lot of work, sometimes on a volunteer basis, and sometimes they'll get legal aid if legal aid is approved for a file. And so all of that back and forth goes on until, we decided, like in Yebes, that this really looked more like a case of an accidental death once we got reports back from the various experts that said, no, the expert couldn't say that an accelerant was used and the time of death was definitely not certain. And all of that really then completely changes the nature of what the prosecution would have been at the time, or whether or not there would have even been a prosecution. And once those reports are completed and we have what we think closed all of the gaps, and as far as we can take it, we will put together the submission, and the student has a lot of input. Over the years, the many memos that the students write on all of the issues, are put into that submission, plugged into an overall outline. Then ultimately that outline and all of the students' work is in this sort of mishmash of a document that the supervising lawyer then has to work into a cohesive submission. And then once those submissions are drafted at the same time that that's being worked on, the student can be helping put the actual application together, which involves copies of the whole trial record, all of the decisions, and all of those have to be together into bound or binders, or a lot of photocopying involved, and a lot of footnotes, and checking the footnotes and making sure that everything we've said in the application is sourced and referenced to somewhere in the record that we're providing to the minister's office. And that process can take upwards of a year of putting that whole application together. So ultimately, in the Yebes case, the application to the minister went was signed, the submissions were signed in February of 2019 and went to the minister's office. And then a year and a half later, on November 7th of this year, he ordered a new trial. And the following week, they managed to get the case on the trial docket in New Westminster. It was called for a new trial, and the Crown called no evidence and invited the court to acquit. And the indictment was read to him. He entered pleas of not guilty, and the court found him on the basis of the submissions of counsel not guilty on both counts, and he was formally acquitted on November 12th.
Can you just give me an idea of you guys' reaction? I imagine it must have been pretty exciting, but at the same time, it's kind of bittersweet too.
Absolutely. Mr. Yebes is in a wheelchair now, so he was in a wheelchair on the side of the courtroom, and he very clearly entered his not guilty pleas. And when the judge pronounced him not guilty, there were definitely tears from counsel and from his wife in the gallery. His nephew is there, and he just kept saying, when it was all over, I can't believe it. I can't believe it after so many years.
Yeah, and for him, I can't even imagine what that would feel like for him, because he was adamant the entire course he was in prison, and that he's always been innocent of this.
Absolutely, and all of the evidence at trial supported how much he loved the boys and did so much. And I remember when we first met, when we had our initial meeting, he was just explaining to me in very factual terms what happened, and his story was exactly the same as he's always said. And at the end of the meeting, he broke down and just said, I can't believe that anybody could think that I harmed these boys.
Right.
He loved them.
And with that case, there certainly was a lot of circumstantial evidence involved. Obviously, the expert opinions, but really didn't give the jury much of a choice at that point. But there was some circumstantial evidence involved in terms of the two boys. There was some difficulty fitting into the family, and with his wife, she was struggling, from what I understand, to really welcome them into the family or to live as a cohesive unit. The wife had moved out with the daughters, I believe. And so there was that backdrop to the case, where there's just obviously some tension with respect to the adoption of these two boys. But in the Supreme Court of Canada decision, there seems to have been some agreement to have the family get back together. And then there's the tragic accident where the boys die in a fire. But the Crown's theory obviously was that at the time they felt, and Mr. Yebes killed the two boys because it was causing tension or stress within the family dynamic, which now with the expert evidence, as you mentioned, that clearly has shown that was not the case, and that it was just a tragic accident. But in terms of using the circumstances to bring in experts and then fit the evidence, do you think that played a key role in his conviction?
There's no question the expert evidence played a key role in his conviction. Circumstantial cases where there is such weak evidence of motive, I think courts have to be really, really careful to use that motive. And Crown Counsel should be careful, frankly, to find motive in circumstances that, but for that other expert evidence wouldn't make any sense.
Right.
If everybody having marital strife, facing the prospect of a reconciliation, it could be thought to have motive to kill their children. It just seems like such an incredible stretch, short of somebody having some sort of psychiatric breakdown, which of course there was no evidence of here. It's just such a huge stretch that could ever form motive for this kind of murder in particular.
And ultimately, this case did go to the Supreme Court of Canada. And can you just explain to us why this case is still very significant?
Yeah, well, this is a case where the found ultimately and established the test for unreasonable verdict, where it's shown that a crime has been committed and the incriminating evidence against the accused is primarily evidence of opportunity. The guilt of the accused is not the only rational inference which can be drawn unless there is exclusive opportunity. And the key point, when I was reviewing it to speak with you today, in this particular case is where it is shown that a crime has been committed. At the time, the evidence before the court, unchallenged, supported that a crime had been committed. But we know now from advances in science that it had not. But because of that legal test and the establishing that legal test for circumstantial evidence, this case has been relied on over 2,400 times whenever an accused is appealing on the basis of an unreasonable verdict. In a case of circumstantial evidence, it can only be found to be reasonable when that test is met. And then the issue of exclusive opportunity. When I reread the case, let's just assume that a crime was committed. The exclusive opportunity piece of this decision just seems to me to be where it fell apart. And you see it in the dissent of Hutchin in the Court of Appeal, where he said you couldn't say that there was exclusive opportunity here, even presuming that somebody else committed a crime, because the one piece that sticks out to me is the whole issue of the assumption that the court made that because he called down to the police officer in here, that the door was open, that he
Right.
knew the door was open. And, that's the kind of, and I know we'll get into talking about it later, post-offense conduct, that to make the assumption that because a person in those circumstances would remember, even if they had locked the door or closed the door, in the chaos of that moment, and to then rely on that assumption to say that they must have known the door was open. It just seems to me crazy.
Yeah, no, I when I was reading the decisions, I was struggling with that because, I have a little guy, and just imagining something going terribly wrong with my son, and I wouldn't have any idea what's going on. Probably, yeah. I'd be hysterical. But I found that very interesting because they made, essentially, because he would lock the door, that was his normal habit.
Yeah.
They put a lot of weight on the fact that the police officer was able to enter the unlocked door, and Mr. Yebes didn't remember unlocking it.
Yeah. To put so much weight on that one small fact. And the other issue that strikes me about that, and this didn't come out at all in the decision, but I had a student that worked on this case one year, and he spoke fluent Spanish. That was just a fluke that I assigned him to this case, because he's half Korean and half Mexican and didn't know he spoke Spanish. But he identified for me that the word in Spanish, and I don't know if this is right, but cerrado can mean locked or closed, and wondered whether or not there was something lost in translation when Mr. Yebes was testifying and not understanding the English word for locked or closed, whatever it was, which I thought was sort of interesting and again speaks to the importance of the person on trial really having a good grasp of the English language and the importance of translators. So
we kind of touched on this a little bit earlier, but in terms, this is a seminal case to really evaluate whether a jury's verdict has been reasonable, especially in circumstantial cases. And now it's come to light that there was almost certainly a miscarriage of justice in Mr. Yebes' claim. And I'm just wondering what your thoughts are that you have this seminal case where they evaluate the evidence to come up with this test that is still being relied upon, but years later it's shown that the evidence in that case is now almost certainly incorrect. It's a bit ironic that you have this seminal case based on erroneous evidence, But I guess my question is as we kind of already alluded to, what errors are we making today? But if there's anything we can do better, or the court can do better to look at some of this evidence. And you've already said keeping an open mind and really trying to challenge it at the time. But it is something I've struggled with, is you're relying on a piece of evidence now, but is it going to years down the road prove to be incorrect?
Mm-hmm. Yeah, it's very difficult. And this case is a prime example of how difficult it is, because at the time, it wasn't until the NFPA 921, the National Fire Protection Act, came in the 90s, that this whole concept of negative corpus and not being able to draw any conclusions from the absence of evidence came into being, in terms of, particularly in fire cases, and the determination of whether an accelerant was present, like here and in another one of our cases that we have yet to submit. The absence of accelerant, there was an absence of being able to determine how the fire was caused. And because of that absence, there was an assumption that accelerant must have been used, even though there was no accelerant present that could have caused the fire, and no accelerant bottles anywhere. I think we need to really question when we have expert evidence that is juxtaposed with, weak evidence that the person committed the crime, to really make sure that the defense has resources to be able to challenge that evidence in any way that is available. So I don't know in the Yebes case whether they applied for legal aid to get funding for an expert to challenge. And I don't even know if at the time they could have, based on what was believed, what was accepted in the fire science community at the time. But what this case, if it responds to your question, says to me is we have to be very careful when we have cases that solely rely on expert evidence, to make sure not only is the expert properly qualified to be giving whatever opinion they've been given, but has the defense had a chance to really thoroughly challenge that evidence, because here it all turned on the expert evidence.
Right. And in terms of people that are of limited financial means, where they are relying on their legal aid or state funded counsel, making sure that those lawyers are equipped with the necessary resources to challenge that evidence.
Yeah. Absolutely. And then, the next thing I would say is, if somebody continues to maintain their innocence, in a case like this, which turned on expert evidence, to continue to revisit it,
Right.
to not dismiss those claims, but to continue to question and look at changes in the areas upon which the person was convicted. We know now that fire science cases, we should be reviewing all of our previous fire science cases, because there have been so many changes in the last 20 years. Pathology, again, I think we've come to a greater understanding after the Gouge report that evidence from a pathologist can be flawed, in a number of ways, unless there are safeguards and challenges to those evidence. And the same with other areas, toxicology, DNA, whatever it is. If the person continues to maintain their innocence and there was little other evidence suggesting their guilt, we have to be open to revisiting those claims and looking at those cases in light of any changes that have come in the areas, the forensic areas that supported their conviction.
Right. That's a really good point, and something I haven't really thought about, because, in a lot of other areas or industries, no decision's ever final or no judgment, right? You're constantly trying to have an open mind and look at how to improve or change things that maybe you thought differently in the past about, right? And I think that's a really great idea, to have judges and courts to be more open-minded about revisiting things. Police and Crown too, yeah.
Yeah, and the creation in the United States in the last 10 years of conviction integrity units within Crown Counsel offices has been a game changer, and many of those conviction integrity units have identified cases of wrongful conviction, because they do just that, and they continue to review these cases, and they work with Innocence Project when somebody continues to maintain their innocence, and together, hopefully, find the truth.
Right. And that's the importance of organizations like the one you're the director of, making sure you guys are doing great work in reviewing things and keeping it at the forefront for people to look at.
Yeah. And you hear, so many stories of people in prison who are pursuing their innocence and writing to lawyers and sending letters, and they can all too frequently be dismissed. And particularly it's worrisome for me when we get letters where the person clearly has some sort of mental disorder, because in those cases especially, I think people are very quick to write them off. But it is in those cases especially where we should have concerns, because that person may have been unfairly targeted, exploited because of their, mental deficiencies, not understood the process, whatever it is. Those are the cases that really worry me, because often the person, when they send us a letter, they're claiming their innocence and they don't really know how to frame it or what could have gone wrong, but they just know that they're innocent, and they may not, I'm sure Mr. Yebes didn't know that there were changes in fire science that might have, now undermined his conviction. I mean, and he's an educated and bright man. For many of these applicants, they're not going to be able to identify what the issues were in their trial that could have gone wrong without the help of lawyers or other eyes on the file.
Right. I think that I'll turn now to just talking more generally about wrongful convictions in Canada. Speaking from my own experiences, I think there's a general conception that wrongful convictions are very infrequent, or they don't happen a lot. And there's a report from 2011 from the Department of Justice entitled The Path to Justice. That's just the short title, but where they refer to, even in that document, as, quote, mercifully infrequent, end quote. And I'm just wondering if you have any thoughts about that statement, or that conception that wrongful convictions don't happen on a regular basis.
Yeah, well, generally I would agree that they're infrequent, but that report is the second of three reports. The first one was in 2005, I believe, and then the last one was in 2018. And it's put out by the federal, provincial, territorial chiefs of police and Crown prosecutors, heads of Crown prosecution unit. And in the 2018 report, there were important new sections on guilty pleas and vulnerable populations. But coming back to your point, the infrequency, yes, infrequent, but not insignificant. They're not as infrequent as people might like to think. And it's very difficult and perhaps ultimately unknowable as to how many wrongful convictions there are out there for a number of reasons. Sometimes people don't come forward. Sometimes, well, I would say in Canada, we just don't have enough eyes on these cases. In the United States, there are over 60 organizations. Almost every state has an organization looking at these cases, and those organizations, for the most part, are staffed with full-time lawyers and sometimes students. And yes, they have 10 times the population that we do, and certainly incarcerate a lot more people. But when they have studied wrongful convictions, experts and scholars in the United States, they've estimated that approximately 1%, the number could be as high as 1%, which in Canada, just doing a little bit of math yesterday, put it at about 242 people with the number of people that we have in prison right now. That's excluding, pretrial detainees. And even one is too many, of course, but, if you think there could be as many as 240 people wrongly convicted in our prisons right now, that's too many people. And even half of that or a quarter of that is too many. But we have very few organizations, lawyers that are doing this work because it is so onerous. It takes so much time, which is why we thought if we married a clinical program, with the work and then put a lawyer with it, that the students could do a good portion of the legwork and the going through documents and itemizing and making charts, and take off some of the burden of that work for the lawyers that are involved. And they're interesting cases for the lawyers to be involved with. They want to be involved, but it's just so much work for them to take on without some other support and funding and all of that. And so the project provides that. But it really is difficult to know. And we're just looking at homicide cases. I suspect that there are far more wrongful convictions in the lesser crimes where people falsely plead guilty for a variety of reasons. And this is discussed in the 2018 FPT report, particularly in Indigenous populations. The wrongful convictions that we have yet to identify, I think, far outnumber the ones that we have identified.
So the 242 people, just as an example, would that just be specifically for homicides or just in total?
No, that's a total. I looked at the current Canadian prison population, subtracted the pretrial detainees, and multiplied it by 1%.
Okay, perfect. Just so I know where that is coming from. And obviously that's just an example or a possibility, but certainly with the cases that have been identified, and we've come a long way in terms of our justice system and evidence and admissibility and all sorts of different issues, but there is still a long way to go in terms of some evidence and problematic issues, I think, before our courts.
Yeah. And following up on that, in Canada, I would argue that there are at least 60 documented cases of wrongful conviction. And depending on how you're defining wrongful conviction, I think other organizations might put that number closer to 100. If you look at Catherine Campbell's book, Miscarriages of Justice in Canada, she lists a whole number of cases that she identifies as wrongful convictions. And that's not an insignificant number. In the U.S., and albeit their justice system is different, they have a whole host of problems that maybe arguably we don't have in Canada. But the number yesterday with the National Registry of Exonerations was 2,697 people that have been wrongly convicted in the United States since 1989. And of those, that is all exonerations, DNA and non-DNA. And of the DNA cases, there were approximately 739 of that 2,600 are DNA cases alone. So, that's another consideration when we're putting together the project is, are you just going to look at DNA cases, or are you going to look at cases where no DNA is available? I think you have to be open to looking at cases where no DNA is available, because that's going to be the majority of the cases where people are claiming wrongful conviction. It's if DNA were available and viable for testing in every case, it'd be much easier to sort out who's been wrongly convicted and who hasn't. But the reality is that in many cases don't involve DNA at all. And then if they do, it had to have been collected properly. It had to have been stored properly. It had to be preserved all these years. If it's a historical case, it has to be tested properly. And then you have to get significant results. I mean, it's a huge, long, and expensive process to go through that DNA testing. So we have to be open to looking at cases where other problems have occurred that we know are problems because of the DNA exonerations. The DNA exonerations have opened the door wide to exposing all of the other problems that we have in the system, because we know in those cases 100% that the person was innocent in cases where there were false confessions and unsavory witness testimony and mistaken identification. Those are all issues that we now only know to be issues because of advances in DNA testing.
There's always those advances like we talked about, and there's always going to be changes, especially in that realm.
Absolutely, which is why, I think if we can learn anything from cases of wrongful conviction, it's about the importance of preserving biological evidence. I cannot stress enough how many cases we have that if we had the biological evidence that was available at the time, we would be able to know one way or another whether we should pursue this case or not.
So just going to the justice system, I mean, there's been certainly a lot of these reports from the Department of Justice and police and heads of prosecution, acknowledgement that training needs to happen for police and lawyers and Crown judges to look at these implicit and explicit biases, et cetera. But your thoughts right now in terms of the actors in the justice system, do you think enough is being done in terms of education and training to avoid wrongful convictions or some of the common pitfalls that we see in these cases?
Well, it's hard to know because it's not particularly transparent, the kind of training that Crown and judges are getting. I know that at judges' conferences and Crown conferences, they often have a session on wrongful convictions, but those aren't open to defense counsel. So I don't know, what they're being told. I've lectured to judges twice and I've not been invited to a Crown conference, but I'm sure they have other speakers that talk to them about wrongful convictions. So it's hard to answer that question in terms of is enough being done. But I would say that I don't think enough is being done in terms of remedying wrongful convictions. Maybe we are identifying the problems and discussing the problems and changing procedures going forward, which is important. But because we know those are problems, we need to be looking back.
Right.
We need to be looking back at cases that involved those areas of evidence where those problems may have arisen and the person is maintaining their innocence. We not only need to be looking back and have the resources to do that and the funding to do that, but we have to be identifying those historical cases as a real concern for the justice system. And if we do that, I think we'll learn from them. We'll learn from those cases as we have done in the past with all of our commissions of inquiry. We've learned about some of the dangers, and that has guided our conduct going forward in terms of our prosecution.
And in terms of these commissions that have looked at a lot of wrongful convictions in Canada, the Justice Lamar and the commission looking at the wrongful convictions of Ronald Dalton, Gregory Parsons, and Randy Drukin, he laid out trademarks to these cases that you see in a lot of them. And this is non-DNA, but for the Peter Beckett case that we're looking at, there's no DNA really involved in it, but it's all circumstantial evidence. And according to Justice Lamar, you see a lack of direct evidence. There's jailhouse informers, demeanor evidence, post-conviction, and then there's obviously the issue of tunnel vision in terms of these investigations from police and Crown in a lot of these cases. So with that in mind, I want to turn to just talking about tunnel vision in general. If you have any thoughts about tunnel vision, because my sense in reading about it and just my experience is that it can be a really easy thing to fall into with these types of investigations in terms of like homicide, or if you have noble cause bias, if you really truly believe that someone has done something, how easy it is to fall into building your case around that belief and making every piece of evidence fit. And I'm just wondering if you have any thoughts in general about tunnel vision and whether you think it can be avoided in these types of investigations.
It probably can't be completely avoided, but there's definitely more we could be doing, in my humble opinion. One of the, and this comes back to your previous question, is enough being done? One of the problems that we run into in investigating claims of wrongful conviction is not having access to the police and investigative file. And there are many reasons why, of course, you would not want to open that file to somebody who's not represented by counsel, and many things that need to be redacted out of that file. But that file often holds the answer to the wrongful conviction. In many wrongful convictions, the new evidence has either been in the file somewhere, or evidence in the file has led to the new evidence. And tunnel vision, I think that ways to safeguard against it. I mean, I think in the middle of an investigation, it's very hard for investigators to not fall prey to, as you said at the outset, people are only human, and one piece of evidence may spark a theory in a case that you may just not be able to shake, and that's going to sort of guide the rest of your investigation. I know some police departments, I think the VPD, have implemented sort of a devil's advocate type of system where somebody is assigned, a police officer is assigned to play the role of questioning and taking the opposite view to ensure that they've asked all questions and are going down the right line of investigation. But I think that role should be played by someone who is not a member of that police department. I think it should be an independent person, whether there's a roster of defense lawyers that works with the investigative team to ask those types of questions as an investigation is going along, to challenge any possibility of tunnel vision. And then, on the review side of things, a more open attitude to the investigative file, a more transparency in being able to review what's being done, what has been done in the past. And, obviously there needs to be safeguards in place with that sort of openness, but I think it could be achieved. And then the other safeguard that I think should be put in place, and this we'll probably get to later when we're talking about accountability, but, is a review by Crown of the police investigative file, because in many of the disclosure cases, wrongful convictions that have involved disclosure, the disclosure failures have occurred between the police and the Crown, not necessarily between the Crown and defense. And, I think that's where you can see the tunnel vision, because there's a relevance determination at the outset in the investigation as to, okay, this information is relevant to my theory, but other information which may be relevant to the case doesn't then form part of the brief that goes to the Crown. And so having just, again, that extra set of eyes of a Crown prosecutor or having, the devil's advocate position, look at, conduct a file review, a sort of an audit to make sure that anything relevant has been disclosed to defense might be an important safeguard. And, I was Crown counsel for 3 years, and I know a couple of times when I asked to look at the police file, I found, and these are much lesser crimes, but, I found information that if I was a defense lawyer, I would want to know, and then asked that it be disclosed. So I think that leaving that relevance determination to the investigators who have charge of the file, we can do better. We can put more safeguards in place so that we don't have tunnel vision is as big as a problem as it is, particularly in homicide files where there's so much pressure to solve the crime and so much is at stake for the accused person.
Right. And just to go back to the pressure of it, not only on police, but a lot of the different articles that I've read talk about how the Crown is supposed to be the advocate that is just putting the evidence before the court. They're not trying to quote unquote win, but because of they're commonly teamed up with police, and a lot of them can kind of fall into the same mindset or same pitfalls of tunnel vision, because they are working with police and they spend, they're very overworked and don't have a lot of resources. And it's very easy for them to identify with, okay, I've spent so much time and effort on this file. I do want to win. I want to get a successful outcome, which usually means a conviction. There's been a lot of discussion about the Crown culture and making sure that it's not about winning, and that Crown is not just promoting the people that are getting the convictions, but promoting the people that are upholding what our courts and what our justice system expects of them, which is to be advocates of the evidence and present it and let the judge or jury decide on guilt or innocence. Do you think there needs to be more of an adjustment for Crown culture in that respect?
Yeah, it's been many years since I've been part of the Crown culture, so I don't know firsthand what it is, and I also think that it's different from province to province. I think if you spoke to most members of the criminal bar in British Columbia, they would distinguish between the relationship between Crown and defense in BC versus Ontario, for example. And, I know lawyers that have practiced in both provinces and have said that it's much, much more collegial in British Columbia. And I think that for the most part, Crown counsel are fair-minded and, want to do the right thing, don't want to be part of a wrongful conviction. And we saw the best traditions of the Crown last week in the Klassen case, where Crown counsel consented to bail in one of our cases. And, in recognition that there was a meritorious claim of wrongful conviction. Again, it's a case that rested on forensic evidence and that we now think is wrong. And both the defense lawyer involved and the court commented and thanked the Crown for the reasonable position it took, recognizing what the evidence was and agreeing to Mr. Klassen's release for the most part on terms. So, the Crown culture, I think that the more that we recognize and praise the reasonable Crown and the reasonable decisions of Crown, which I think happens quite frequently, in British Columbia, the more the culture will change. At least I can only speak from what I know in BC, that I don't think Crown are promoted on the basis of the number of convictions they get. I think that Crown counsel in BC who develop a good reputation, develop that reputation because they take reasonable positions that are not, as the defense bar likes to call them, true believers, that they understand the frailties of the system and are humble enough people to take the high ground and recognize errors where errors have been made. And that sort of attitude, I think, is what gains the respect of lawyers and judges, not the attitude of taking a hard line and unreasonable positions in the hopes that they're going to get somebody convicted. I don't think anybody sets out to be involved in convicting an innocent person. Nobody wants to be involved in that sort of a situation, but people can get caught up in the adversarial in the adversarial approach that we have in criminal trials, for sure. And there are some areas that, I know there's debate about this, but where maybe we shouldn't have an adversarial approach. For example, the concept of courts calling an expert, rather than having each side call an expert and have this battle between them. There might be some sort of systemic changes that we can make that take that element of the adversarial process out. And that might help a little bit with alleviating any sort of adversarial relationship between Crown and defense.
Right. And just to make it clear, and I'm not trying to suggest that Crown or police are malicious in these wrongful convictions, because in most of these inquiries after the fact, the commissioner very explicitly states that these people are good people, and that they just fell into one of these biases, or that's so easy for many of us to fall into. So there's usually not a malicious person behind these wrongful convictions. It's just, as I think it was Justice Lamar said, it's kind of like a runaway train where lots of people just jump on and it gets too far, and then these errors can happen.
Yeah, as Lamar's inquiry pointed that out. I mean, as have lots of the other inquiries.
So in Peter Beckett's case, the reason I was asking about Crown in general was because he had lots of colorful interactions with Crown in his case, where he was accusing them of all sorts of different things that we'll review in the podcast. But the common pitfalls in these wrongful convictions that are present in his case, and we're not suggesting that he's been wrongfully convicted. We don't know at this point what the final outcome is, but the trademark pitfalls are involved in his case. Those things involve the unsavory informants or the jailhouse informants, the demeanor evidence, and post-conviction conduct as well. So I just wanted to discuss those with you. And I figure we'll start with jailhouse informants. In general, my reading of a lot of the case law and just how concerned judges and these inquiries have been with admitting these people to give evidence in these high profile cases, they are, as one commissioner said, the most deceitful and deceptive group of witnesses known to frequent the courts. Whether we should just be banning them outright, or if you have any thoughts about using that type of informant.
Yeah. A number of years ago, I think, in maybe response to these commissions of inquiry, there was a Crown sort of policy. I don't know if they're called directives, I can't remember, but, on the use of jailhouse informants. And they are supposed to be limited to very, very few number of cases where they're absolutely necessary, because they are so dangerous. And, I think that in the cases where, well, first of all, I think they should only be used if there is absolutely no other option. And if they are used, there have to be all of the safeguards that we can put in place to make sure that their evidence is truthful. And there is a recent, well, not so recent, but my colleague that helped start the project has written on a case called Serahungo, Serahungo. And it's a case that highlights how important corroboration is in cases where we have unsavory witness testimony. And, unsavory witness testimony ranges from just a witness who falsely testifies for perhaps some personal motive, to the jailhouse informant who, does this as a career. But in those cases where we have jailhouse informants who are the most unsavory of unsavory witnesses, we must have strong corroboration, not just that a crime occurred, but that this is the person that committed the crime. Often when you look at these cases where the courts talk about corroboration, they talk about evidence being corroborative that doesn't go to identity. It just goes to the fact that the crime occurred, and the person giving that evidence could have known those pieces of information from either being there themselves or being the actual perpetrator, and so we have to look at what kind of evidence we're using as corroborative evidence, and really make sure that in cases where those rare cases where we have to use a jailhouse informant, that their evidence is not the only evidence, or even not the most significant evidence against the accused. And if we're going to rely on it at all, there have to be warnings to the jury and strong corroboration, so that maybe their evidence forms a piece of the puzzle, but is by no means a significant piece.
And I guess that, because that is balanced with the fact that if you're a criminal, potential that you're going to be committing crime in front of other, I'm going to call them less reputable people, right? They're potentially people involved in crime or fraud or deceit themselves. And obviously there's a balancing that, as the famous quote from 1982 from Justice Torrey, that the Crown cannot always rely on local parish priests to prove its case. Mm-hmm. Sometimes the prosecution must rely on thieves, prostitutes, perjurers to prove their charges. Yeah. But as you said, it really comes down to what the evidence is that they're supplying and whether there's any corroboration of that evidence.
Yeah. And coming back to that first question, I mean, that's another thing is, what is the evidence that they're supplying? How important is it? If it's a case where you have that evidence from other areas, you know, like whether if their evidence comes through other witnesses as well, or you know it by the way of other circumstantial evidence, then I absolutely would say avoid using the jailhouse informant. I mean, I don't think you can use a jailhouse informant's evidence to corroborate, other evidence. I think that's just inviting prejudice. But if it is the only means of getting a certain piece of evidence that's important before the jury, and it has to be done to prosecute, then there need to be very, very strong safeguards.
Right. And in fairness to the Crown, I did review their desk policy on jailhouse informers and unsavory witnesses, and they do have, they spell it out very clearly in when they should be using it. And corroboration is a big part of that. And they try to get other people to review it, and they have their own processes, which we will review on the show. But in a lot of these cases, you do see unsavory people coming forward, jailhouse informants, to provide testimony, especially when it's been well publicized, and just the dangers inherent in those types of testimonies.
Yeah, in the States, it was such a huge problem. I have a few reports in the office about snitches and how many people were wrongly convicted based on jailhouse informant testimony, where the informant had testified in many different cases. There are ways in prisons to get information, and people will use it to their benefit at every opportunity.
Yeah, they usually have motivations for themselves, usually to get a better deal or out or financial.
Even if it's not getting out of prison or financial benefit outside of prison, there are so many benefits that they can gain within the prison system, just lenient treatment, I don't know, being taken out of segregation, or different little perks that they can get, something extra in their cell, or, whatever it is that is going to make life easier for them, can be a huge incentive to lie.
And especially for juries, it's been shown that this type of testimony is really persuasive. Like they really seem to buy into this type of testimony. And there's the warning the judge is supposed to give jurors. Do you think the warning is enough? Do you think they should be almost like a mini seminar in teaching jurors why this evidence is so problematic?
Yeah, in looking at wrongful conviction cases over the years, and I'm working with some SFU students to try to get some stats, but anecdotally, I think that more wrongful convictions happen in cases where there are juries than judge-alone trials. And in many of those cases, the jurors were warned, they're given the instruction. So I'm not a big believer that the instruction is enough. And I hope that at some point in Canada, we change the laws around being able to study juries, because particularly when we know so much now about wrongful convictions and how it can happen, being able to understand how juries come to decisions and what they place importance on in a trial, I think can only help us understand and move the justice system to a place of increased fairness. And now all we can do is look to studies that have occurred in the States with juries. And in many states, they are people not unlike ourselves as Canadians. So I think we can rely on those studies. And we know from those studies and from anecdotal stories we hear about what juries rely on in cases. And it's often not the right evidence. So do we give a more fulsome instruction? Do we allow expert evidence to talk about different areas that will educate the jury, like a mini seminar? Those are possibilities. But I think many of these issues are difficult for people with a legal education to grasp and understand. Never mind asking a juror with no legal education to grasp the concept from 2 or 3 sentences. I think that's unfair. And I think it's a bit of a fallacy to think that juries who are making these very important decisions are fully grasping all of the issues in a way that, and applying them in a fair way.
And certainly we are going to discuss juries and some of the advantages and disadvantages, or at least in theory, of what juries are supposed to be doing in the justice system. And this ties into the next thing I want to discuss with you, which is demeanor evidence. And in general, all of us, I think, including myself, think we are really good reads of people, that we can tell when someone's being honest or deceitful, holding back something from us. We all have, and study after study, decades of studies have shown that we all have this confidence, and we'll review some of that research in the podcast. But going back to juries, I imagine it would be the same type of thing with juries. And then you're in a group setting where strong personalities might help sway other jurors, and there could be some reliance on some less than certain evidence, and demeanor evidence certainly would fall into that. So reading into somebody's behavior, or believing that you can tell the way they look represents the way they're feeling inside, or their honesty or deceitfulness. And I sent you over just a little brief quote from Malcolm Gladwell's book, Talking to Strangers, from 2019, which he's someone I look up to quite a bit. His podcast and writing is something I really enjoy. And just his review of what he calls transparency, which he thinks is very flawed and comes from this folk psychology of Hollywood and novels, where as in his words, the character's jaw drops and the eyes go wide when they're shocked or scared or frightened, is not at all what we actually see in reality. For a lot of people, they don't express themselves in those commonly held behaviors related to fear or shock, honesty, truthfulness. So in terms of relying on demeanor evidence, just your thoughts in general on demeanor evidence, and relying or putting a lot of stock in that for jurors and for us in general.
Yeah, it's a huge mistake. Did you listen to Gladwell's book, or did you read it?
I read it, yeah.
Yeah, I would highly suggest listening to the audiobook, because he reads it and it's done like a podcast. And yeah, it's excellent. And I've just put in the chat to you little video clips, and this is one of them on lie detection and demeanor evidence that is put out. It's Dr. Pars Anders Granhag from Sweden, and this is part of a series of impact of human factors on wrongful convictions, and there's about 5 or 6 little videos you can watch. But in this one, this is a Swedish professor who has studied this for years and years, and points out, as you say, that people are terrible at detecting when other people are lying, including police officers. And the difference is maybe like 4%, like greater than chance. It's 50-50 for the regular population, and maybe police have a 54% chance of getting it right, whether people are lying. So it's a real problem for our justice system, which has relied on for so many years, and currently does rely on our ability to try to determine if somebody's telling the truth. And I think, like Gladwell says in his book, that studies have shown that we're almost better off just relying on comparing inconsistencies in statements, like doing the reliability analysis on paper and forgetting about credibility altogether, looking at all of those other indicators of truth telling, rather than relying on these human indicators that we believe for so many years are indicators of truth telling, which we know to be false. In all of these cases, I think when you look at wrongful conviction cases, and in some of them anyways, where comments have been made about the demeanor of the witness and the ability to then therefore rely on them because they seem to be telling the truth, or the demeanor of the accused post-offense, which we now know to be completely false because the person's been proved to be innocent. I think we have to learn from these cases that we're doing something wrong in criminal justice if we are placing any significant amount of weight on somebody's demeanor. And this has been identified in judicial decisions and in legal scholarship, yet in criminal court, it happens on a daily basis, in provincial courts, in your regular run-of-the-mill criminal case or higher case, or cases in higher courts, I should say, where we are relying on demeanor evidence. And I don't know how you get around it other than, again, having very strong requirement for corroboration. But it's a very dangerous area that I don't, I really, really think we need to be careful.
I've read numerous decisions where there's justices talking about why we need to be careful with demeanor evidence, and yet there's very high levels of our court, including many from Supreme Court of Canada and even in our province, British Columbia Court of Appeal, where they say even recently that assessing credibility, inconsistencies, and discrepancies in a witness's evidence also includes an assessment of his or her demeanor. So having that eyes on, looking at their face, seeing the way they behave and answer questions is still given a lot of power and authority in our judicial system. And it's almost a reluctance of our courts to, even in the cases where they are pointing out the risks of relying on this evidence, they almost completely ignore any of the social science or psychological evidence. Like there's very few discussions about the studies and research that show why this behavior is problematic. And I'm wondering if you think there is a reluctance on our justice system to get into that realm, because they're still like, it's almost like they're protecting in the role of the trier of fact and the trier of law, and they don't want to open that can of worms. Do you think that's a fair assessment?
Yes, I do. I think that there is a reluctance. Well, we see it in Canada. They're sort of pushing the boundaries a little bit in some cases in the United States in accepting social science evidence. But just as science evolves, as hard science evolves, our understanding of human behavior evolves as well. And particularly in the last 10 years or so, our understanding of neuroscience and the brain and how the brain operates and the interaction of that hard science in looking at how the brain operates with social science evidence. We have to evolve along in the court system in that area as well. And that has to inform how we understand witness testimony. With everything we know about false confessions and eyewitness identification and motives behind false testimony or false accusations, unsavory witness testimony, we recognize it in these commissions of inquiry and in understanding wrongful convictions and in articles about legal scholarship and maybe some cases, but we don't then apply that knowledge to the everyday criminal case and make changes, for example, in admitting expert evidence in these areas in ways where we admit expert evidence in other areas that some might argue is equally questionable, like in Abbey, where gait analysis was admitted. Why are we admitting evidence of gait analysis, but not evidence of someone who has their PhD in neuroscience and can talk to us about the way people's brains operate and how that might affect behavior? It doesn't really make any logical sense, the kind of expert evidence that we have admitted versus the kind that we're not admitting, or evidence on eyewitness identification. We're not admitting experts that study memory and can tell the trier of fact about why witnesses' brains may or may not encode certain information in certain circumstances. That seems to me to be pretty important evidence in many of these cases. Why people falsely confess in a case where maybe the accused has all of the indicators of confessing falsely. I mean, as long as we are, again, maybe with a jury instruction, telling the jury or the trier of fact, look, this person is not usurping the ultimate role of the trier of fact in determining guilt or innocence, but they're giving you information that might help you understand the evidence or put it into context in a way that we know, when it has not been put into context, has led to wrongful conviction. And I think there's a really big cultural piece to this question as well, in talking about demeanor, because we know, and Malcolm Gladwell talks about it in his book as well, that different cultures have different reactions to events, different cultural norms in human behavior. And particularly in Canada and the States, where we have so many different cultures, living under one roof and adjudicated by the same justice. We have to be more sensitive to the differences in behavior as between cultures, particularly in tragic or traumatic events, right? And when people are testifying.
And demeanor evidence and then the post-defense conduct as well. From Beckett, Court of Appeal decision, referred to as settled law that an accused conduct after a crime, such as fleeing the scene, can constitute an inference of guilt may be drawn. But there's the same type of risk that from our Court of Appeal in 1998 that people can do stupid things after being involved in a traumatic experience. And to put so much stock into post-defense conduct, again, in the Beckett case, that's almost entirely the case against him. His statement he gave to police after his wife had just drowned, because it was so detailed and specific that they thought that was unusual. And just in general, some conversations he had with some friends afterwards about Google Earth, and then there's the circumstantial evidence.
Yeah.
Just if you have some thoughts on why post-defense, because I mean, defense can use post-defense conduct as well. It's not like it's just reserved for the Crown. Like if someone does express awe or shock or they're crying at a crime scene, defense is going to draw that evidence in front of a jury as well. But why courts need to be careful with that evidence.
Yeah, courts absolutely do. And you know, what struck me in Beckett was the court somehow draws a distinction between the interpretation of demeanor by the Hawkins in talking about the Hawkins interpretation of Beckett's demeanor and the inference that was asked to be drawn about indicating that there was marital disharmony versus the demeanor in the Google Earth piece of evidence, which was admitted about being able to construe his demeanor as relief. And I didn't understand how they could distinguish between demeanor in the one context and demeanor in the other and not admit the demeanor evidence in relation to the Hawkins testimony versus admitting the demeanor in the Google Earth testimony. I don't know, maybe I misunderstood something, but you know, that's just the kind of sort of hairline distinction that we shouldn't be making in these cases, you know, like we shouldn't have to be analyze such minutia of people's behavior and drawing inferences from that can point to their guilt in a criminal context, you know. And as you say, yes, open to defense to use it as well. But to be fair, if we're going to question its use by the Crown, we have to put the same safeguards in place if defense relies on it, asking the court to draw inferences from somebody's behavior. I think based on what we know now of how human behavior can differ so greatly based on their personality and different circumstances. I mean, you look at the Amanda Knox case, you know, in Italy, and how much weight was placed on her demeanor after the fact. And now we know that, you know, she was wrongly convicted. I mean, that's one case out of many where people have been accused and wrongly convicted, where their demeanor was looked to as indicative of guilt. It's a really dangerous area, you know, post-defense conduct. I mean, I don't know. In some cases, I think maybe it shouldn't be admitted because of the danger of the jury not understanding how difficult it is to take anything from demeanor and the risk of prejudice and misusing that type of evidence.
I'm starting to be more mindful of your time here because you've already been generous enough. But the case R.V. White in 2011 with Supreme Court of Canada, where two guys get into a fight and a handgun goes off and one of them is killed. And the question would be whether he had the necessary culpability to be convicted of murder. And he ultimately was convicted of murder. And the Crown put a lot in, I think it was in the closing submissions, where he said the accused didn't have any shock or no hesitation before he then fled the scene. And there was a talk about hair splitting. Justice Rothstein for the majority talked about it wasn't the fleeing necessarily, it was the fact that he didn't hesitate. That was the important component to look at, and that someone who's innocent is more likely to stop and, oh no, what did I do type of thing before they would flee the scene.
I just that's just crazy making for me. I just find that to draw inferences based on, as I said, the minutia of people's behavior and assume that behavior is indicative of anything. Even statements people make. I mean, after such a traumatic incident, how people conduct themselves and statements they make, and to draw conclusions based on anything that happens in that first little while after an event like that occurs, I think is just so dangerous. Human experience is so varied. How can we make assumptions about how a person should behave based on how we would behave, or about how popular culture dictates someone should behave in a given circumstance?
Right. And again, just I always find, there's always the argument out there that judges and lawyers are always good at creative writing to try to find reasoning for their judgments and decisions. But I was thinking that with that hair splitting, where it's not the fleeing, it's the hesitation that they thought was appropriate for the jury to consider. And again, Justice Rothstein, for the majority in that case, it talks about how the jury system is predicated on the conviction that jurors are intelligent and reasonable fact finders. And there was other evidence involved in that case too, that the angle that the bullet entered the chest and other contexts, which Justice Rothstein, to be fair, considered in the context, and he thought that was a big component of his rationale. But certainly Justice Binney, for writing for the dissent, brought up the accused essentially admitted that he committed some sort of a crime, or that he was involved in a crime, and to say that he wouldn't have run away from the scene because he committed manslaughter versus or aggravated assault or whatever, it's just as likely that he would have run as if he committed murder, right? So
absolutely,
it does seem to invite asking the juror to interpret someone's intent or culpability based on a lack of hesitation or a lack of shock.
Yeah, I agree.
But then you have, and you'll correct me on another name here, I'm sure, but David Paciocco.
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 I think it's Paciocco.
Okay, that sounds better than mine. He's now an appeal judge in Ontario, and he's written textbook after textbook. He although he indicates from an article in 2016 how complex demeanor evidence and post-conduct evidence is, and that it should be identified as something different than just circumstantial evidence, he believes that it still should go to a juror if it's relevant to a live issue and it's a reasonable interpretation of that demeanor evidence. And he went through a lot of decisions to kind of come up with his conclusion that it should be specific live issue, and then if it's a reasonable interpretation that should be acceptable for the courts. But again, even in his article, and I mean, the guy is brilliant, but there's no mention of any discussion about social science or behavioral research. And it's almost like there's this,
or wrongful convictions, or cases where people have been wrongly convicted in part based on demeanor evidence.
Yeah, exactly. And to say, even in his article, that common sense and human experience furnish the test for relevance, which is again based on his review of the law, but there's no real critical assessment of that test, which again to me seems like it's almost like the way of the court inoculating itself a little bit and making sure that they keep all the power in determining questions of law and fact.
I think it's getting better, but over the years, it has surprised me how little even defense lawyers and judges that I've spoken to know about wrongful convictions, the causes of wrongful convictions, and the science behind, or that we now understand, that ultimately led to the wrongful convictions. And maybe this comes back full circle to your earlier questions about, is there more we can be doing? Is there more education? Many of the judges' conferences are optional, and certainly conferences for defense lawyers are optional, and I think Crown conference is probably required, but maybe it's just frowned upon if you don't go, and I know people skip out of sessions, etc. So there's no required education about this. In law school, it's an optional course for people to do. In addition to the project, there are 5 spots in our seminar, wrongful conviction seminar, reserved for people who are not in the project, but again, not required. One of the things I hope to implement in the next couple of years, and I had a student last year do a directed research who put together a proposal for a course on forensic science, and the Gouge Inquiry does recommend that education on forensic science and problems with forensic science start in law school. And I hope that UBC will be one of the first law schools to have a full course in forensic science available to law students to start learning about these issues. But coming back to your Choco comment, I would love to see in these kinds of articles and analyses what they make of wrongful convictions and the fact that this type of evidence has led to wrongful convictions in the past. Can we keep applying the same rules that we've applied for decades, knowing that people have been wrongly convicted, relying on those rules? Or do we need to make some changes? Do we need to try to think outside the box and reconsider how we can operate in the justice system in a fair way that will safeguard more strenuously than we have done so far to protect against wrongful convictions?
Well, I've had you on here for almost 2 hours, and I definitely appreciate your time and insights. It's been great. We could talk about this for hours and hours and hours, I'm sure.
I could talk about it for hours and hours.
So in general, where can people, or how can people support the UBC Innocent Project?
You can go to the UBC website and look up Innocence Project and donate. Yeah, that's the main way to support us, is to provide funding to do the independent expert reviews that we need to do, or testing in the cases where we can get our hands on evidence to be tested. But yeah, it's those secondary expert reports that are important and cost money, because all of the work that we do, apart from my position, we have to raise money for. So it's always a struggle, and we have to make hard decisions about things we're going to test or reports we're going to get based on how much money is available for a particular case.
Okay, awesome. Well, we'll definitely encourage people to support the great work you guys are doing. It's through the work of you and your team that these mistakes and reevaluations occur. So definitely appreciate your time today. It's been great to get your insights, and again, I can't thank you enough for coming on and doing this.
Excellent. Well, thank you so much, Trevor. And
thank you.
Good luck with everything.
Awesome. Thanks again.
Okay. Bye.
Bye.